plenary power or any silence in 370 which allows them to do what they wanted to do. That's not their case. So we are now adjudicating a case which they have not pleaded before your lordships. If some private citizen were to do that, would your lordship ever allow it?
So, Mr. Sibal, you are saying 373 doesn't exist practically. Correct? That's your argument. Their argument is 373 exists and we've taken that.
No, they say 370.
That's the second part. Whether the process applied by them under 373, if it exists, is the proper process as per 373 or not, is the second limb of the...
But I'm saying something else to your lordships. They proceed on the basis that 370 exists.
Correct.
Therefore, they are not saying that 370 doesn't exist after the Constituent Assembly was drafted and nothing else happened and there's no Constituent Assembly. It's not their case. We are now adjudicating upon a case which is not the case of the Union of India before your lordships. Many things have been said, Mr. Sibal, from both sides which are really not, in our view, prima facie germane to the main issue is this of 370, as you say, one side of the argument that with the Constituent Assembly going away, 373 really did not subsist, only 371 survives. Their view is that 373 subsists and that's the route we have adopted. Second limb arises if 373 exists and the route they've adopted, what's the correct route, permissible or not? But that's what I'm arguing. When I opened, I only argued on the route. If your lordships remember, correct. I never went into any political argument, any historical context. So that is your argument. That I never talked about lack of sovereignty. I never talked about federalism. I never talked of any of that. I said this is the process they have adopted and this process is unconstitutional. I remember you also said that it's not for us to, or for you, or to suggest what is the alternative. Exactly. And then when an alternative route is followed, it will be tested in its own way. Correct. This is the route they have adopted. And they have not taken a 368 route. They have taken a 373 route. So the first question that your lordships have to answer is 272 valid or not? And that we'll have to decide. Yes, and that can't be decided. That can't be decided because that they have followed the route of 370 proviso, Malad. It is their case. Yes, yes. So the problem there with the argument is that 370 can't be decided in the context of the argument now raised. That after the Constituent Assembly is not there, we can do what we like. But that's not what their case before the court is. Their case is that they have applied the proviso and substituted Constituent Assembly for Legislative Assembly. That's what the CO says. That's right. So you have to test only that, which is what I argued. I didn't argue anything else. We are not asking you to argue beyond it. No, they have forced me to argue beyond it. They have forced me to argue beyond it. But let me go back a little.
Assuming that they have followed the route of the proviso to 373, I don't think we can prevent them from sustaining the exercise of power on the ground that even independent of that we are entitled to.
That's not in their counter. I'm sorry, Malad, that's not their case.
Just my...
The proviso.
That was for incorporating the proviso.
But I'm only saying that they are...
Sorry, 367 to the... That was for amendment to the treaty.
That's what I'm saying.
But ultimately then they invoke the power under 370 clause 3.
With the proviso, Malad?
Yes, with the proviso.
But that's all I'm saying, Malad. I'm saying nothing more than that.
We have understood your argument on that.
Yeah, I'm just saying, Malad.
In fact, we had put that question to the Attorney General also.
You also given the answer, Malad. This is a sui generis provision of the Constitution, must be interpreted in its own terms. That's all that I'm saying, Malad. And kindly counter.
This part, I think we've conceptualized, we have put our doubts to you, have conceptualized.
Giving life to 373 through Article 367. That's their counter. That's all that we are testing, Malad. Okay, so Malad, that's done. No. Now kindly go back to the list of dates. And just orally, Malad, I'll mention to your lordships. 20th of June in 2018. Well, that's 19th of June, BJP withdrew support. 20th of June, Governor Malad puts the Assembly in suspended animation.
Now, the latter part, now you are going into the...
I'm going to test 356.
356.
356. And the dissolution of the Assembly on 19th of December. On 21st of November 2018. Now, Malad, the normal process is, Malad, for the governor has the power to keep the Assembly under suspended animation without the aid and advice of the Council of Ministers. That power is given under 92 of the Jammu and Kashmir Constitution, which he did.
Which
he did, Malad, on
20th of June 2018. Now, the Jammu Kashmir Constitution also says that this will last only for 6 months. That such a decision of the governor will last only for 6 months. That is set out in Section 92, subclause 3. That such an order will last only for 6 months. Now, which means by 19th of December, there should have been revival of the assembly, because the assembly was not dissolved. See the political motives and the illegality in the whole process. This can't go beyond 6 months, beyond 19th December. So he has to revive the assembly. There's no dissolution. So on 19th December, he dissolves the assembly. On 21st November, he dissolved the assembly. Now, dissolution can't take place without the aid and advice of Council of Ministers. Section 53 of the Jammu Kashmir Constitution. Section 36, 38 and 92 are the only exceptions under the Jammu Kashmir Constitution. I mentioned it earlier also, where the governor can act on his own. But 53 is not. 35, 38 and 92. So, Malads, he could not have dissolved. And after dissolution, 356 can't be imposed.
After
Muller's dissolution, Article 356 cannot be imposed. These are Constitution Bench judgments of this court. Now, your lordships asked me the question last time also, you've been asking other council also, why did you not challenge it? Number we could not challenge as far as the governor's order of 20th June is concerned, because under the Constitution of Jammu Kashmir, he had to put the government back in place within 6 months. Where was the occasion to challenge it? Council of Ministers would have been back in place.
What would happen if there's no conceivable government formation possible?
Well, he can't do it. That's a point.
Mr. Sibal, that's little saying that because it was tenure or 6 months, I can't challenge this wrong.
No, I said I haven't challenged it.
You can't challenge it.
I can't. When I said I can't, I mean we knew, Malas, that
you can certainly challenge it, and people do challenge it.
But Malas, the government was to come back in place, Malas, was to be put back in place.
That may be little.
The government was to be put back in place within 6 months, Malas.
My only question is how, if in 6 months no government is feasible, possible, then necessity would require a resolution, would it not? What
I'm
would
sorry?
happen? Let us say there is no government possible. Then whom will he put back in? What kind of governor?
So, Malas, what you do is you impose 356, then you dissolve. With the process of under 356, Malas, I've explained it last time also, that you keep the assembly under suspended animation. You see if you can form a government or not, because 356 is a temporary provision to restore democracy. If you find that there is no possibility, after imposing 356, you dissolve and hold elections. That's the process.
So then the dissolution should have taken place under the rubric of Article 356.
That's correct. That's correct. And that's a Constitution Bench judgment. I'll show that to your lordship straight away. Because the governor was ruling for 6 months. Where is the question of 356? So you do it this way, tell the governor, whereas he sort of puts it in suspended animation, lets the 6 months almost part when the government, when the two parties say that, look, we are ready to form the government, but that's not proved, Malads. Then on 19th December, President rule is imposed after the assembly is dissolved on 21st of November. Couldn't be done. Then if that's bad, and that has to be decided by this court, because that's the basis of 202, 272 and 273. So whether we challenge it or not, that's the very basis.
This can happen, right? Because the Section 92 power is sui generis.
Yes.
Normally, even when
he has to act on the aid and advice.
Normally, when an assembly is placed under suspended animation, as we call it, that's also an exercise of the 356 power.
That's on the recommendation of the governor, Malad.
That's on the recommendation of the governor.
The governor, that it can't be carried on in accordance with the provisions of the Constitution. Then 356 is, well, that's what happened.
And the recommendation of the governor again is on aid and advice, or that would not be on aid and advice?
No, it never is.
It will never be on aid.
It never is.
So the question doesn't arise. So we are just wondering, according to you, the dissolution of the assembly on 19th of December is wrong, 19th of November is wrong, Because it had to be
21st
by
November. Yeah, 21st.
25th of November is wrong.
21st November, yeah.
Because there had to be aid and advice. There was no aid and advice.
Apart from that, Madas, where was the occasion for 356 at all? Because he was running the administration. Madas, he's running the administration. There cannot be a constitutional failure. That happens only when the government cannot run in accordance with the provisions of the constitution.
But therefore, no, but we're just testing it like this. Suppose the governor's dissolution is, according to you, incorrect. The consequence would be that at the end of 6 months, the legislative assembly has to be restored.
No.
The suspension would come to an end after
After
6
6 months,
Yes. Then
If
the
the
Council of Ministers have to be
Council of Ministers has to be formed.
correct.
Now, taking your argument to the logical conclusion that, look, the dissolution was wrong and the governor had to necessarily at the end of 6 months
Before.
before 6 months, restore the legislative assembly, lift the suspended animation,
Yes.
invite a government. In which case, can the government of India not have then exercised, the president not have exercised the power under 350?
Correct. So then he would have had to make a recommendation that this is not, they are not functioning in accordance with the provisions of the constitution because the governor was ruling for 6 months. Where is the occasion, Malas, for him to at that time exercise that power?
But if no state government is possible, nobody is agreeing to combine together.
But that's fine, Malas,
Keep the facts aside.
in which you impose 356. Don't dissolve it. Malas, that's the whole problem. You impose 356.
And keep the assembly in suspended animation.
That's always the case. I'll give you several notifications. I don't have the time. That's always the case. What you do is you keep the assembly under suspended animation. You try and, you have to restore democracy. So at some stage you feel that now it's time to hold elections. You dissolve the assembly and announce elections. That's the process followed in every 356 proclamation. You never dissolve the assembly immediately, but then you have to hold elections. The democratic process can't be stultified, can't be used in this fashion. Because this was, as I said, this is a political decision. It has nothing to do with the constitution.